Okay, let's start this way. Because in 1985, when we passed this law, what was it seeking to achieve?
So at the time when it came to administration of estates after somebody died, it was quite difficult. We found that it was mainly left to customary practices, and then spouses, especially widows and children, were left to the mercy of the family. So they had to decide whether they liked you. They would determine what would come to you. So a woman and her children could go to bed in their house, lie on their bed. They wake up and then the husband and the father is deceased and they have nowhere else to sleep because everything will be taken away from them. So there was the uncertainty as to what would happen when somebody passes. What happens to their estates? Are the rights of the spouse and children protected? And we needed something to assure regulation, to give one structure, to give fairness and procedure so that everybody knows, it is clear as to what happens to the estates of a deceased person when he dies without making a will, and then making sure that spousal and children's inheritance and property are protected.
Okay. Let me say that we've also been joined by Madam Betty Mould Idrisu, member of the Council of State and former Attorney General and founder of the African Women Lawyers Association. Madam Betty Mould Idrisu, good morning to you and thank you very much for joining us.
Good morning. Thank you for having me.
Great. I'll get to you shortly, but let me just continue with Marion a little bit, then I'll get to you. So yes, you're telling us, so after 40 years, what would you say has been the impact of PNDC Law 111?
At the time we passed this law 40 years ago, it was revolutionary. Ghana was the first in Africa to have it. Can you imagine the impact that was? Women could for the first time be assured that I am guaranteed property. I am guaranteed property rights. My children are safe. Their school fees will be paid. They'll be provided for. I don't need to beg to somebody. I would not be taking as another economic inheritance to the family before I can be given something. It was revolutionary. So first of all, it protected their rights. It safeguarded women and children, especially because, let me say this, men didn't have that problem. They already had their rights guaranteed, and the women were not at the liberty of either the customary practice, the family, whether somebody liked you or not. So at that time, that is what it brought us. Okay. That guarantee and safeguarding of your property rights.
Great. Let me get to Madam Betty Mould Idrisu. And, after 40 years, Marion has been telling us, that safety that it brought, the fact that you knew that at least you're guaranteed something after the demise of a spouse. And really, the reality is that after the demise of your husband in those days. But after 40 years, is the law fit for purpose?
I would not say it has not been fit for purpose. What I would say is that there is still a lot of work to be done in the implementation of the law. There's a lot of work to be done. There's a necessity to amend the law, and there is still the necessity for the judiciary and for the traditional communities and the families themselves to know the way forward. It is sad that we are still going to court on the most basic issues which were decided 40 years ago. Some of it is due to the way the law itself was crafted, because at that time it was a revolutionary law. I don't know whether Marion touched on the fact that it came as a bundle of laws, and this guaranteed the fact that there would be accountability from the head of family. It plugged up the loopholes in the marriage of Mohammedans, and it plugged, several other loopholes in the traditional system. But still, it has not been enough. And we are constantly calling upon the government to do more in this regard.
It's not been enough. Why hasn't it been enough? What's the challenge?
The challenges are multiple, and I'm sure Marianne will go into that. But the challenges are from the way the law itself was written. In those days, it's understandable. But you can't have a law saying that 3/16 of the property should go to the spouse. I mean, who divides a property into 16 portions? It was an unknown concept. And then 9/16 to go to the child, and if there's a surviving parent, 3/16. I mean, it was totally confusion. And then it left out a couple of the core issues under our traditional law, i.e., there may be multiple wives equally legitimately entitled to a piece of the property. How do you divide one house into 16 portions or 3 portions and give 4 wives what of the 3 portions? It did not take into account dependent children. It didn't take into account jointly acquired property. With the nuclear family becoming more predominant in Ghana, this is a real challenge. Husband and wife or husband and wives might acquire a property jointly, and then at the end of the day, we are being told to share that one property with children which might not be hers or theirs. So the core issue of our tradition, that is having different children from different wives and yet asking them to share one property, it has been very difficult. And here again, I must applaud the Ghanaian judiciary. The cases they have done have been far-reaching, impactful. What we need to do now is to amend the law, to bring it into today, 2025, 40 years afterwards, to bring it into the reality of today, where husbands and wives are now co-equal joint partners in acquisition of houses, properties. They operate joint bank accounts, they operate joint businesses, and yet the law doesn't recognize that.
Great. And I'm just checking. I see the part you're talking about that says where the intestate is survived by a spouse and by a child, the residue of the estate shall devolve in the following manner: 3/16 to the surviving spouse, 9/16 to the surviving child, 1/8 to the surviving parent, and 1/8 in accordance with customary law. Okay. 3/16.
Very difficult. It was very mind-boggling for us in the beginning, and we believe that the Law Reform Commission wrote it this way based on some European concepts, because those concepts were never heard of. These 16s were never heard of under Ghanaian customary law. And we were operating within that context, the customary law system, where the family, the wider family, took everything. And the spouses and the children were not entitled to anything except what the customary successor gave them.
Okay. So, I mean, after 40 years, I mean, you've talked about the law changing. The law should, evolve. But even before that, you've talked about the sharings and all of that. There's some also raised the concern about even the definition of a spouse. Today, there are those who have argued that a spouse may not necessarily be one that you've gone to marry with drinks, but if your actions have shown over a period that you consider this person to be your partner and society recognizes same, then that person could benefit from your estate, isn't it?
That person can benefit from your estate if the family, the customary successor and the head of families enable them to do so. This is the paradox that we need to change. we don't have that system of common law marriage here in Ghana. You have our systems of marriage by ordinance, customary marriage, and the Islamic marriages. You have to fall within these three systems. When we tried to get Parliament to understand that there are other systems there which prove inequitable for a woman, i.e. a man may stay with you 1 year or he hasn't performed any customary ordinance Islamic thing, that he has stayed with you. In the eyes of the world, he is your husband, you are his wife, but he has done nothing for you. In those days, and then the men leave, you move on. When he dies, you get nothing, even though you might have acquired property with him. When you are with him in such a situation, the family will throw you out, that you are not a wife, if they don't like you. And that throwing out is done after immediately the man passes away. It's our courts that have now come to really stretch the boundaries of traditional and common and customary law, and have tried to help the such situations over the past 40 years. And I always stand up for the judiciary of Ghana when it comes to engendering the inequities that mainly women have suffered. I'm sure Marian made the point. These things apply mainly to the women. Some cases, some rare cases, it might happen to the men. But most, 90% of the cases, happens to women.
Great. Madam Betty Modi-Drisu, thank you very, very much for joining us this
morning. Thank you very much.
Yes, we know you have other engagements. So let's get in studio. And before I get to you, Yao, let me just do this with Marian Darlington. So let's look at it this way. We know that sometimes, certain rulings of the court would cure certain challenges with some laws. Has the courts not found a nice way of curing some of these challenges? Because I can't in my word understand what 3/16 is. Okay. And 3/16 and 1/8. Okay. Yes. I look at 3/16. I just in my word can't understand. Hasn't the court found a way of curing some of these?
Well, to be fair, the courts don't do the administration unless it cannot be done, and then they'll be called on to, but it's not very common. So the courts don't actually deal with 3/16. These are left with practitioners and then the administrators. And we have found a way. But let's be real. If you have one house, how do you divide the house into 16? If you have a car, how do you divide the car into 16? So these are some of the challenges. But to answer your question, yes, the courts have found ways to deal with some of the problems. For instance, now, by virtue of practice and with the support of the judges and some of the courts, we have the presumption of jointly acquired property. So as practitioners, we are able to, in the application of a letters of administration, say that this property was jointly acquired. So the only part under intestacy is 50%. This is not provided for by the PNDC Law 111. It's one of the challenges that we have identified, but it's one of the things that currently the courts are able to cure, and so far it's been great. Unless one party, and the only party who can actually rebut it is the dead person. So there's a presumption that if you have a spouse who is surviving you, the person jointly acquired that property with you. Okay. Some of the challenges we have, and the reason why I'm sure as practitioners we had to do this, was because imagine that somebody died with leaving one spouse but had 10 children with many other women. And PNDC Law 111 says that the matrimonial home goes automatically to the surviving spouse, that is that one wife, and then his 10 children. So these are 10 children who were probably not even her children. So she's built this house with this man, lived in there for so many years, he passes, and then his 10 children come in, and they are all entitled to this house equally as her. So we saw the injustice there, and we said, no, we need to intervene. She has 50% share. So then his 50% is the only one that falls under intestacy. So the PNDC law 1 will not touch hers. It would only address the 50%. So now the 10 people plus her will share only 50% of that property. So yes, the courts are trying. They are stretching, as Auntie Betty says. They are stretching the boundaries. But we need an actual amendment to be able to say this is actually what it is, so that everybody is clear. So that the day that the judge is not happy with you, you know that this is what the law says. It is not that you'll be at the mercy of the judge to say, okay, today I'm in a good mood, so yes, you can have 70%. But everybody will be clear from the beginning.
Yeah, let me bring you in here, because some have actually argued that the very thing the law seeks to cure, it encourages. Because if you have the family still involved, the likelihood that the family frustrates, say, the spouse or the surviving spouse is very high, isn't it?
Okay, so let me step back and then I would. For me, I think one of the greatest assets of that law is the prohibition against rejection until devolution, and making an offense of ejecting a spouse, right? So baseline, we know the historical fact, and I think that the Leonard Senior mentioned it. The moment the man dies, the woman is out at best 40 days, right? Or if you don't perform the widowhood rite, in some cases which are very extreme and against human rights, you're out, because the presumption is you killed him for property. And these are perceptions that is lived with us until today. A man 80s die, and yet family still think that the wife killed.
How? 80 years.
Exactly. Right.
I can't
And these are real cultural nuance. So the culture is almost postured to say, if a man dies, a woman killed him. And so to that extent, it's always about how do we make sure that she gets close to zero property. So for me, one of the greatest assets of that law is to make sure that you cannot, whether you die testate or intestate, you cannot sack a woman from a house she lives in before the death of the husband until all the legal issues around it is settled. And for me, that's a good thing. Now, back to the question as to whether or not the law has not enabled what it seeks to cure. From the perspective that I consider that the greatest asset is to say, you live in the house until we can settle all the legal questions. And there are very, very difficult legal questions around this law. No two ways about it. At least the woman gets some solace and lives in the house until the lawyers can go back and forth without anybody sacking her from the house. It gives her some reprieve, saves us some of the difficulties in life, and then the lawyers can answer the more difficult questions. Now, is it a bad thing getting the family involved? I don't think so. Particularly if you consider that the body still culturally up until today belongs to the family. The family is primarily responsible for having raised the person, but also having been responsible for putting the person to rest, right? Because as a wife or as a spouse or as a child, depending on the custom of the people, you don't have a right to your father's body up until today. The man dies and it's the family who is burdened with the responsibility of making sure that the man is buried in accordance with the custom. So,
except that these days they transfer the cost to you.
Again, they may, but culturally,
yeah, you know that culturally.
I know.
Culturally, they tell you that
you have to pay for.
When they say the children buy the coffin,
I know.
In certain Akan cultures,
you do.
When they say the children buy the coffin, because the children may not be old, when they say the children should buy the coffin, the mother's family would not have to pay for it.
Completely agree.
Yes.
Which is the point I'm making, that the perception is that the family is still left with duty to the deceased, even though they may pass the cost on to the children, but they still have duty. And so I think the thinking of the law is to say, if a parent is alive, give the parent something for at least the work they may have done in making sure the person became what they became, and also for the person who customarily succeeds the person, give them something, and I think it's 1/16 if I'm not mistaken. But the bigger point is that if we go back to asking the question, who devolves yes, 1/8 for customary successor and 1/8 for surviving parent, right? Who devolves a property into 16, right? If you take what the surviving spouse is entitled to, it's about 18.7%. So usually, in practice, you would say that children in total is entitled to about 50% of the entire assets. The remaining 20% will go to the surviving spouse, and the rest is shared between surviving parent and the customary successor. But the technicalities around it, particularly if the asset is not divisible, somebody has to pay somebody off. And usually if they're from different parents, you will get the difficulties in somebody rather litigating than settling, because they are settling scores at the time of death. And so ultimately, as I keep on saying, the baseline for me is that the law served this purpose in this time, and still does serve a great purpose in this time, at least by sheltering the woman during the litigation. But the essence of whether or not the law is served as in settling disputes around how you devise estate and devolution of assets in an estate, I think it's probably left us with more litigation done, which is why I say make a will, buy a life insurance product from Empo Life and save yourself the hassle, because if you take the wills out, life insurance is separate in many sense. So the person you mentioned in your life insurance policy, for example, is entitled to that life insurance policy. And again, these are conversations in will that is important to have on, but you can clearly separate you can make a will to determine what happens to your estate. And I think for me, that is the focus. To the extent that the law remains like this, that should be the focus of many conversations.
We'll come back and talk about this. We'll talk about what should change in the law. Or maybe we should probably be doing a new law totally. Valentin is lawyer, African Women Lawyers Association, and Yao Sumpa is lawyer with Empo Ghana. So, Marian, what do we do? How do we solve this?
First of all, I think we can all agree that we need an amendment. And so we are calling for an amendment. Madame Betty Mould, when she was Attorney General, placed the first amendment bill before Parliament over 15 years ago, and that bill hasn't been passed for various reasons. But the top of it was just no interest. Let's just face it. Even before we started, you said this law is for women. So when it is seen as a women's issue, it's not prioritized.
But it should be prioritized.
It should be, but it is not a women's issue.
I mean, I don't see how somebody dies and you're going to fight over his property. I mean, the wife and children, give it to them, let them go.
So that's the first thing. The second one is that as long as you're going to do an amendment, there are some things we want to include in the amended act or in the bill. We want to see some of these definitions of who a spouse is made clearer. We recognize that now there are various forms or modalities when it comes to the family setting. It is not as it used to be before. So we want it recognized. We want the various facets included, and then we want them recognized so that it is clear, so that nobody dies, and then we have to now determine who is the spouse, who is this person, what could their rights be, are they entitled, do they have any rights? We don't want those ambiguities anymore. We want better provisions made for spouses in polygamous marriages. The current one we have is woefully inadequate, and we want to see something better. Now, when it comes to assets, we're in 2025, there are many forms. It's moved beyond house and land. There's digital assets now. People have shares. There are various forms of investments. We want to see that what happens when somebody has these things, because you cannot tell me that somebody should really divide their digital assets into 16 and these things shouldn't. Then we want better provision and protection for children.
Okay.
Now we're looking at children in varied forms. Again, we're in 2025. The definition of who a child is has grown. How a child becomes a child has grown. We want the various possibilities of who children or who a child can be or who a child is to be reflected and provided for. We have children who are born under surrogacy. What happens to these things? Because we don't want to leave it to family members who come and say, this was not your child, or you were not, this person is not your biological father, so when they pass, then you are not entitled to anything. We want these things to be clear. Now we want advocacy. Because what is the point of having a law when nobody knows what is in there, when nobody knows how they will be benefiting from such a law? We want people to know. You'll be surprised that after 40 years, there are people who do not know what is in the PNDC Law 111. They know it exists, but they don't know to what extent it can protect them. So these are some of the changes that we want to see, and that is why I'm hoping you will be there on Tuesday at UPSA when
Yes.
Auntie Betsy addresses, and she is delivering a public lecture on the 40 years, what we've achieved so far, what the challenges are, and what the way forward is. And so that we can have some of these discussions and create better awareness, hopefully to push Parliament to pass an amendment, because we desperately need one.
Great. Yeah.
Winston, so let me start from the cultural point of view. I think we've come from a heritage where Wofa Ohoye and Go school, right? And there's still a big part of our societal arrangement that feels entitled to Wofa Japadie, because we're matrilinear in many sense. I think sociologists beyond the lawyers must understand this society in a way that we must understand that self-acquired properties of persons may be shared in different ways. And in allocating for the new law, sometimes you can make a law and the society will fight it, or society, and which is one of the classic things we're seeing with this law. And so, yes, we definitely need an amendment, but that amendment must carefully appreciate the society in a way that the law is also sociological in its orientation. That may sound very philosophical, but Wednesday, I think is very important. At the base of it, of course, this concept of sharing into 16 is one of the things I think should be done away with clarity as much as possible, because the confusion it introduces, you have no idea. The second thing I would say is in terms of devolution of the administration itself, we know people who hold on to administration for years, right? And so the new law must also allocate to when administrators must really close out administration. There are provisions in other laws, but I think it will be more comprehensive if I know that I'm appointed as an administrator within the boundaries. I owe these beneficiaries who hold this, I should close it out within 1 year, and the obligations really spelled on the administrator, who are legal trustees of the deceased, right? And finally, I think that's what I started with. There's nothing more assuring, in my humble view, sitting in heaven or burning in hell, knowing that I still determine things on earth, right? Make the choice, and I think maybe I'm speaking to myself. Make the choice who benefits from your assets. As a society, we've left it to many people. We've not taken agency for ourselves and allowed other people to determine what happens to our sweat, our brow, our intellectual property, our hustle over a long time. So you die, and you may be happy in heaven or wherever you may be, or whatever your faith may be. And your life sweat, people are really battling over it for years, to the point that businesses go to waste, property spot. And I can't begin to tell you litigations I've been involved in that was completely needless, right? But those are, and I'm sure lawyer here will tell you the same thing. You can solve that if you take agency into your hands and say, I will make a will and determine who has what of mine. Or at the minimum, share it before you die. Have a proper gift. Do a gift deed. Share it before you die. Sign it off. determine who has what before you go. But in the end, make sure you have a life insurance product from EMPO,
Very crucial.
and then determine that your EMPO product goes to your beneficiary you've named in your policy. And thank you, Weston.
Thank you very much, Yao. Marian.
You see
so-
how Yao says make a proper gift. You see how he qualified it by saying proper. It
Yes.
should tell you that there's a problem. You can't just gift things. You
Of
die
course.
and it'll be worse than
Of course.
if you hadn't gifted at all. So just make a will.
Just see a lawyer, make sure that you are gifting properly in accordance with law.
Well, I like that bit about gifting properly in accordance with law. One of my lawyer friends told me, if you want to gift anything to your son, come, let me do it for you properly.
Yeah.
That
Yes.
one, when you die, there are no payments to be made. Thank you.
Interesting.
Yeah.
That's a tax dimension to the conversation.
Yeah. Anyway, thank you very, very much, Marian Darlington. It was Lawyer African Women Lawyers Association, and thank you very much, Yasun Palaya with MPO Ghana. So, Marian, before you go, the program on the 16th, right? UPSA auditorium. At what time?
Yes, it's at 3 p.m.
Okay. Thank you.
Prompt.
All right. Thank you very much. Is it
No,
open to all of
It's
us?
open to the general public. Madam Betty Mold will be delivering her lecture, and then there'll be a panel discussion after that.